Insurance professionals work hard every day to keep people safe. But as technology transforms the industry, how can insurers protect not only their clients, but also shield themselves from ever-changing cyber risks? My name's Elizabeth Blossfield, and I'm the host of the Insuring Cyber Podcast, a bi-monthly look into how the world of cyber and the business of insurance are connected. The US Securities and Exchange Commission in July adopted rules that require public companies to disclose certain information about their cyber risk. The rules, originally proposed back in March of 2022, not only require disclosure within 4 days of any cybersecurity incident a public company believes is material in nature, scope, timing, and impact, but the rules also require public companies to describe their process for assessing, identifying, and managing cyber risk, as well as the likely effects of a cyber incident on their company. This also means that companies will be required to describe their board of directors and management's role in overseeing cyber risks. Compliance is required for most public companies beginning in December of this year, which has left many companies and their insurers wondering what the effect will be on the cyber and D&O landscape. To unpack all of this, I'm speaking with 3 guests on this episode. They're discussing not only the benefits of these rules in providing more transparency as companies think more critically about their cybersecurity, but also the challenges that could arise regarding litigation, liability, reputational risk, and access to insurance coverage, among other things. My first guest is Greg Van Houten, an insurance recovery attorney with Haynes and Boone. Greg represents corporate policyholders in a range of industries and sectors across the U.S. For the past several years, he's been named a rising star by Super Lawyers, one to watch by Best Lawyers, and he's the author of the Policyholder Playbook, a collection of techniques used by policyholder advocates. He gave a lot of advice to insurers and policyholders alike for navigating compliance with these new rules. Check out our conversation. Hi, Greg. It's great to be speaking with you today. How are you doing?
I'm doing great, Elizabeth. Thank you so much for having me. How are you doing?
I'm doing really well, thanks. Yeah, I'm really looking forward to our conversations. I appreciate you taking the time to be here. I know that we're talking all about the SEC's new cyber incident disclosure rules that were announced in July. And I was curious just to start off if you could sort of give an overview of some of the biggest considerations for corporate officers and board members with these new rules.
Yeah, of course, I'd be happy to. Before I dive into those considerations, I want to back up and just talk very briefly about what are we talking about here with these new rules. The SEC calls these its rules on cybersecurity, risk management, strategy, governance, and incident disclosure by public companies. As you mentioned, these were finalized in late July. And there's 2 parts to these rules that I'm going to be referencing, and I bet we're going to be talking a lot about these 2 parts during our conversation today. Part 1 is the disclosure of material incidents via a Form 8K or Form 6K, and the effective date there is December 18th of 2023. And then there's the second piece, the second part, which is a company's disclosure around strategy, risk management, and governance practices with respect to cybersecurity. And that will happen via Form 10K or Form 20F. And that will be due beginning with annual reports for fiscal years ending on or after December 15th of 2023. So with both parts, we're right around the corner. And so I think your question is a great one. What should corporate officers and board members be considering right now? I have 3 concrete considerations, and I won't get into insurance aspects yet. I am an insurance professional by trade, but first, tabletop exercises, as in practiced real-time responses to simulated cyber crises. Those are an absolute must. I wouldn't even call those a consideration. Why? Well, primarily because of the timelines associated with the disclosure of material incidents. I mentioned that disclosure via Form 8K or 6K. Well, that has to happen within 4 business days of the entity determining that a cyber incident was material. That's really, really fast. And so because of that requirement, it's really important that companies are practicing responding to cyber incidents so that they can meet that requirement if and when a cyber incident arises. Right. And so in the need to message appropriately when such an incident happens, we know that phraseology, framing, it can affect investor behavior. So there's a critical need to practice, to ask, what will we do with this type of breach? What will we do with this kind of cyber theft? How are all cyber incidents going to be elevated to management as soon as possible? Once a cyber incident is identified, who needs to be called? IT personnel, public relations, crisis management experts. Those are questions that need to be answered, and they need to be answered before a cyber incident arises. And that's where these tabletop exercises come in. All corporate execs and board members would be wise to consider working with a consultant to get such a process off the ground, if they're not already. Many companies are already doing that work. Second, and this is for board members specifically, cyber strategy, risk management, and governance needs to be elevated to the board level if it is not already. Many boards are here already, but all boards should consider adding a cyber dashboard to their structure, to their practice, a dashboard that can be leveraged during board meetings in the same way the board leverages their financial dashboards. It's just that important. And although there is no requirement per the new SEC rules that a company disclose in its 10K the cyber experience of their board members, having a board member with that background would not be a bad idea. And although companies need not disclose the cyber experience of their board members, they must disclose in their 10Ks the board's oversight of risks from cybersecurity threats. And if applicable, they must identify any board committee or subcommittee responsible for such oversight. And so third and lastly, corporate officers and board members have to consider and must be concerned about potential shareholder litigation that will follow the company's disclosure of any material incident. That has to be a concern. We know how the plaintiff's bar operates, and folks are talking about this already, that companies should be concerned in the same way they're concerned with any significant M&A activity. It almost always, if not always, leads to shareholder litigation. And one way that corporate officers and board members can cabin that risk, perhaps, is to, one idea is ensure that the company's policies are aligned with what the company actually plans to do, both on the front end to prevent a cybersecurity incident and on the back end to respond to an incident. That sounds simple, right? Have your corporate documents reflect what you're actually going to do and what you plan to do, but it doesn't always happen. And the consistency is important, as one tried and true play in the plaintiff's bar playbook is to assert you didn't do what you said you were going to do. Another way to cabin that risk, the risk of shareholder litigation and the repercussions of that, and I think we'll perhaps get into this later, is to consider securing comprehensive and gap-free cyber insurance and D&O insurance. So in a nutshell, those are three key sort of concrete considerations: tabletop exercises, elevate cyber to the board level, and then think about ways to cabin risk associated with potential shareholder litigation that could follow or come on the heels of a material cyber incident.
Yeah, I think those are all great points. You've given such a great overview of what exactly is going on. And, it sounds like there's so much for companies to consider. And this is an important framework for how they can sort of get started complying with these rules and, also improve their cyber posture as the landscape is always evolving. And I know you mentioned that you have a focus on insurance. So I was curious, for insurers specifically, what are some of the biggest considerations with these rules?
Yeah, I'll dive into three. And these are concrete considerations. It's easy to say, companies should carefully review their cyber and D&O policies, but what are concrete things that risk managers can be doing from an insurance standpoint? I think they have to be thinking about this in light of these new rules. First, with respect to cyber coverage, make sure that your application for that cyber coverage matches what you disclose in your 10K with respect to your cyber practices. Why do I say that? Because in the event of a cybersecurity incident, insurers will now review policyholders' publicly available cybersecurity, risk management, and government practices and procedures, which are going to be found in the company's 10K, and they may deny coverage if the insured's actual cybersecurity practices and procedures are inconsistent with what they disclosed in their application. I'll give you an example of why that could happen. I was reading a cyber policy earlier today issued by Hiscox, and there's a provision in there, and this is a very common provision found in most liability policies. It says, you warrant that all representations made and all materials submitted by you or on your behalf in connection with the application for this policy are true, accurate, and not misleading. And if we learn any of the representations or materials were untrue, inaccurate, or misleading in any respect, we are entitled to treat this policy as if it never existed. And so what Hiscox could do is they could say, hey, what you told us you were going to do in your application is inconsistent with what you're telling the SEC you would do in your 10K. And they could presumably deny coverage for a cyber claim on that basis. So what to do about this? The same folks who are working on the disclosures on the 10K side, they should be involved with the insurance application. Make sure that your insurance broker is leveraging the work that you do with your 10K in your insurance application to make sure that there is consistency across those two documents. Now, on this, interestingly, some cyber insurers are actually incorporating the company's 10K disclosures into the application. I was reviewing another cyber policy issued by Trisura Specialty, and it provides that with respect to publicly held companies, 10K filings are included as part of the application. They're actually incorporated into the application by reference. So how does that play out? Well, let's say after a cyber incident, a shareholder alleges that your true practices deviated from the practices disclosed in your 10K. Well, with this Trisura policy, that could also constitute an allegation that your true practices deviated from those disclosed in your insurance application. So Trisura could, in theory, deny claims based on alleged misrepresentations in your insurance application. So again, in short, consistency between your 10K disclosures and your insurance application and what you're actually doing. Second concrete consideration on the insurance side, and this particularly regards the 4-day disclosure window that we were talking about before. I think companies need to consider bringing their cyber insurer under the tent with respect to the disclosure required by the new SEC rules. Why do I say that? Because most cyber policies, like most liability policies, they forbid policyholders from admitting or assuming any liability or obligations without the insurer's prior written consent. But what I'm worried about is when a cyber incident arises, the policyholder, because of the new SEC rules, is going to scramble to disclose to shareholders the cyber incident within the 4-day requirement. In their disclosure, if they arguably admit or assume liability or an obligation, the insurer could deny coverage under those provisions that I was talking about. And I know companies are going to hesitate to bring yet another actor under the tent, in addition to lawyers, crisis response experts, IT experts, public relations, and the like. But you have to consider the insurer if you want to preserve coverage and take away that potential defense. So another concrete measure there. Third, and lastly, and we could go on for a while on this, is consider finding a cyber insurer who offers preventative cyber services as a part of the premium. Your broker should not only be focused on price, on premiums, but should also make you aware of and assess other programs beyond and other factors beyond the premium when making recommendations as to where to go for your cyber insurance. Policyholders can then leverage those services and disclose them in their 10K as part of their cybersecurity risk management practices. What exactly am I talking about? For example, Chubb, a major player in the cyberspace, they offer a cyber vulnerability alert system, That's at no additional cost, and Chubb will send out blasts on a biweekly basis containing pertinent information about newly identified vulnerabilities of the software that the policyholder uses. Beazley offers something similar, so does AIG. And I think these are, and why are insurers doing this? Because they too want to prevent claims, right? They want the premium, but no claims. I think the policyholders also don't want claims, and they want to be able to tell their shareholders about all the things that they're doing to prevent claims. And I think policyholders can turn to their insurers and leverage some of these services that they're offering, often for free, often for reduced prices, to really set themselves up for success.
Yeah, those are all great points. And that last point you mentioned is really interesting because there is sort of a responsibility on the part of insurers to educate their policyholders as well. As you mentioned, it can help prevent claims and be sort of a proactive measure in that way. And you sort of answered my next question really well, because I was going to ask, about some of the concerns I've heard about carriers maybe denying claims or pulling back on coverage. Some insurers maybe declining coverage to companies altogether if they see them as more vulnerable in light of this new rule. So it sounds like those concerns are legitimate, and that there's a lot that companies will need to consider regarding that with their insurers.
Yeah, I mean, if I can respond to that, Elizabeth, I think that has been a concern. You hear that, carriers are pulling back on cyber coverage. I'm not so sure that that's true, and I'm not sure that even if it was true that the new SEC rules would sort of exacerbate that trend or cause insurers to decline coverage. I mean, one thing, just talking about sort of the history here, and the idea that carriers have been pulling back on coverage, per a recent market analysis by AM Best, US cyber premiums increased by 50% in 2022, but then through Q1 of 2023, they were relatively flat. And Marsh recently reported that cyber insurance prices dropped 4% over year on average in Q2 2023. So I think things are actually beginning to ease a bit. And there are some credit rating agencies that are positing that that's happening in response to recent insurer profits and competitive factors, and really a reduction in claims experience. And so I'm not so sure that carriers are pulling back on cyber coverage. I think that actually it is expanding and becoming perhaps a bit cheaper. And that is perhaps because companies are becoming more sophisticated with respect to awareness and prevention of cybersecurity issues. And they're developing more policies and devoting more resources to preventing cybersecurity issues. And for that reason, I don't see the SEC's new rules negatively affecting the availability, price, and scope of coverage. I think it could be just the opposite. You'd expect less claims the more companies are doing to prevent attacks. And there was some concern in the comments to the SEC's proposed rule that increased disclosure would effectively give cyber criminals a roadmap to effectuate a cyber attack. But to address that concern, the SEC actually tweaked its rules so that the disclosure of technical sensitive information is not required. So I don't see that as a concern anymore. And also, the SEC's new rules are designed to ensure that companies are not as vulnerable to cyber attacks. Now, preventing cyber attacks will now be top of mind. It has to go in your 10K. So in theory, if an insurer is underwriting a public company for cyber insurance, that insurer should have little concerns about the company's cyber vulnerability for all the reasons that company states in its 10K disclosure. So summing all that up, I'm not convinced that this is going to sort of harden the market. And the market is sort of already heading in the right direction, and hopefully it keeps heading in that direction.
Yeah, definitely. And that's good to know. There are always rumblings of concern about, the availability of cyber insurance as, cyber attacks continue to grow. But it sounds like, as you mentioned, a lot of companies and insurers, this has been top of mind for many years. So it sounds like we're heading in a good direction. And I know you mentioned at the beginning of our conversation some of the concerns about potential liability or litigation challenges on the policyholder side. Did you have anything else to add about some of those challenges and what, companies should be doing now to prepare to navigate them?
Yeah. As I noted earlier, there has to be a concern about shareholder and securities litigation that may follow a company's disclosure of a material cyber incident. I mean, it's already happening. Yahoo settled its data breach related securities fraud case for 80 million, and then its derivative suit for 29 million. What shareholders are alleging is that public companies have improperly affected their stock value, either by failing to timely disclose data security incidents or vulnerabilities. Now, to be fair, not all shareholder derivative suits arising out of cyber incidents have been successful. Suits against the boards of Wyndham, Target, and Home Depot were all dismissed upon motions to dismiss, but still, a shareholder suit is a shareholder suit that you have to lawyer up for and that you have to defend. And there's always the risk of an adverse verdict in any litigation. And folks are talking in this space about after these rules go into effect, an expectation of an increase in these types of shareholder and securities claims. Perhaps plaintiffs will allege that the cybersecurity disclosures required by the SEC rules were misleading, that what a company disclosed in its 10K was misleading because they failed to warn of the risk of incidents, or perhaps plaintiffs will allege that the company's disclosure after a material incident was misleading because various aspects of the incident turned out on full investigation to be different than what was initially disclosed. So to answer your question about what should companies be doing to address these concerns, or this concern of potential shareholder and securities litigation following a cyber incident, at first, I already mentioned this, I think you have to ensure that your disclosures, that a company's disclosures in the 10K required by the new SEC rules reflect what the company is actually doing and what the company actually will do. Because again, the plaintiff's bar will jump all over any inconsistencies. And second, I would encourage public companies to work with their insurance broker and their insurance coverage lawyers to ensure that they have a seamless insurance program, likely consisting of cyber and D&O coverage that will cover the costs associated with shareholder type suits following a cyber incident. I'll note that with the Yahoo shareholder derivative suit, the $29 million settlement was paid by the insurance carriers. That is the type of protection that companies subject to these new rules should consider purchasing.
Yeah, that makes sense. And, we've spoken a lot so far about some of the challenges in navigating these new rules, as well as, the cyber incidents and, companies that have, risks with, their cybersecurity. But I want to talk about some of the benefits of having rules like this in place as well. So I was curious, how these rules will provide more transparency regarding cyber incidents and, cyber risk management at public companies.
Sure. Gary Gensler, the chair of the SEC, I think he summed it up nicely in a statement released on the day the SEC approved the new rules. He said, I'm pleased to support these rules because they will enhance and standardize disclosures to investors with regard to public companies' cybersecurity practices, as well as material cybersecurity incidents. He went on to say, I think companies and investors alike would benefit if the disclosures were made in a more consistent, comparable, and decision useful way. And that's what these new rules do. And all of that makes sense. In a way, before these rules were enacted and before they go into effect, I mean, public companies are currently operating in sort of a wild west of sorts. There was a sense of concern, and I'm pulling this from a post by Sidney Posner at Cooley, that company disclosures were not consistent, comparable, or decision useful, and were including different levels of specificity regarding the cause, scope, impact, and materiality of cyber incidents. And that lack of consistency and utility arguably leads to investor confusion and information deficits, and also some angst on the corporate side. I imagine there's been a lot of hand-wringing among corporate executives and board members regarding what to disclose, when to disclose it, and how to disclose it. Standardization, which is brought by these new rules, can even the playing field and reduce that angst. And on the investor side, there's also the benefit of not having to worry, at least not as much, about companies not disclosing material cyber breaches. The SEC doesn't want another Yahoo situation where there's a December 2014 data breach with respect to more than 500 million accounts, but it's not disclosed until September of 2016. I think investors should cheer on that transparency.
Yeah, that makes a lot of sense. And, you've given a lot of advice throughout this conversation for both companies and insurers alike regarding these new rules. But, given everything that we've talked about, I was curious if you have any other advice for corporations for managing their cyber risk, as well as, insurers for sort of moving forward in light of these new rules.
Yeah, on the corporate side, the non-insurer side, I'll say this: gather the professionals and do it now. Most public companies are already there, but these rules go into effect in a few months. A material data breach on Christmas Day, 2023, will be subject to the 4-day disclosure rule. So gather the law firms, the IT forensic personnel, public relations, crisis management experts, maybe insurers, as we discussed earlier. Integrate them with your cyber task force. Conduct the tabletop exercise to practice what you will actually do. How will you react to a cyber event, and use that exercise to improve your processes? They say by failing to prepare, you are preparing to fail. That rings especially true in this space, given the timelines that are very aggressive that were set by the SEC. And from the insurer perspective, and really I'm thinking about underwriting cyber and D&O risk in light of these new rules, I'm not sure much is going to change with respect to their approach. Underwriters will now have more data points to assess during underwriting. They'll have the benefit of the company's 10K cyber disclosures. But I wonder if on the cyber side, given the SEC's greater involvement, whether cyber insurers whose form policies exclude coverage for securities claims, which we do see in some cyber policies, whether those insurers might reconsider that exclusion. Although we typically think of a securities claim as implicating D&O coverage, there are some D&O form policies that exclude coverage for cyber-related incidents. So some policyholders may have a gap in their program, and that's something that's being discussed in this space, are these gaps that may be exploited by these new SEC rules. Cyber insurers could consider plugging that gap. And if they're worried that that's a risk that should be picked up by D&O insurance, well, maybe include an other insurance provision that can dictate priority of coverage. And those provisions are, axiomatic. It maybe D&O is up first, followed by cyber as excess, or the other way around. But I think such coverage would be attractive to the corporate publicly traded policyholder, given their potential concerns about cyber-related securities claims increasing in the wake of the new SEC rules, and this concern about gaps. Will it cost money? Of course, but it might be something worth taking to market.
Yeah, that's really interesting, and sounds like it could be a whole other episode conversation. So, you've mentioned a lot of great points. There's so much to consider. And, as you mentioned, I'm sure we could go on and on for, another half hour with this, but I think you've given, insurers and companies a lot to think about, and a great framework for how to sort of think about these new rules as they're implemented. And I've really enjoyed this conversation. So thank you so much for taking the time to speak with me.
Thank you, Elizabeth. I really enjoyed it.
I learned so much from Greg, and I learned just as much from our next two guests. Bob Wice and Jim Rizzo both work at Beazley, where Bob is head of underwriting management for the company's global cyber risks division, and Jim is product leader for US D&O and executive risks. They had great perspectives on the impact of the new rules for both cyber and D&O insurers. Bob has been with Beazley since 2005, initially as a large account cyber and tech underwriter, and then in 2011 as the focus group leader for the US Cyber and Tech team. As a graduate of Georgetown University and Emory University School of Law, Bob is also an active member of the Georgia Bar. Jim joined Beazley in 2010. He brings 17 years of underwriting experience to the executive risk team, with a specialty in directors and officers and employment practices liability for publicly traded and large private companies. He graduated from the University of Florida with a degree in fine art. I loved getting the chance to speak with both of them. Here's what they had to say. Hi, everyone. I'm here with Bob Wice, Head of Underwriting Management for Beazley's Global Cyber Risks Division. Hi, Bob. How are you?
Great. Thank you for having us.
Yeah, thanks for taking the time. And I'm also here with Jim Rizzo, Product Leader for US D&O and Executive Risks at Beazley. Hi, Jim. How are you?
I'm great. Thank you.
Awesome. Well, thank you both so much for taking the time to do this. I appreciate it. I'm, really looking forward to our discussion. But before we get into the SEC's new cyber disclosure rule, I just wanted to start off talking about some of your backgrounds and your roles at Beazley. So, Bob, I'll start with you. Could you sort of give an overview of some of the work that you do at Beazley?
Sure. I've been at Beazley for over 18 years. In the first 15 or so, I ran the underwriting team in the US. And in 2020, I transitioned over to a new role that we created, Head of Underwriting Management for the Cyber Risks Division. And we focus on data science, exposure management, and underwriting actions to improve and focus on growth, profitability, and efficiency for the Cyber Risks Division.
Awesome. That's great. Thanks, Bob. And then, Jim, what about you? Can you give an overview of some of your background and the work you do?
Sure. As mentioned, I'm an executive risk underwriter here at Beazley. I've been with Beazley for 13 years, and I'm also the US D&O product leader. I've been specializing in public D&O for 22 years, and my entire career has been based out of New York in an underwriting capacity.
Awesome. That's great. Thanks, Jim. Well, it sounds like you both have great experience. So I'm really looking forward to talking to you. I know, we're talking today about the SEC's new cyber disclosure rule, and, there's a lot to get into. So my first question is for both of you, but Bob, I'll start with you. What are some of the benefits of this new disclosure rule? And then on the other hand, what are the biggest challenges that you see with it?
Sure. Yeah, the rule is really a culmination of a lot of effort and oversight by the SEC in determining what public companies need to do to offer up more transparency around not only incidents that happen on their networks or third-party networks that affect them, but also just governance and corporate oversight of cyber risk management generally. The benefits would be that there would be more transparency. So from an investor or shareholder or stakeholder perspective, there would be more transparency around cyber risk management and oversight by the C-suite and the board, which I think we all would think could be a challenge, but certainly a benefit to those who are looking to understand the inner workings of the organization and the investment in that organization. But it really does reinforce the need for organizations to really focus in on cyber risk management as a top level issue that requires board oversight, that requires a real dedicated resource allocation and funding to cyber exposures that need to be contained. So this is not necessarily a new development in the sense that organizations that are publicly traded should be focused on cyber risk management as a top level issue, but it just is another iteration of active engagement to ensure that cyber risk management and a focus on it is at the highest reaches of an organization. In terms of the challenges, we're talking about a 4-day disclosure of material incidents. Challenges abound with respect to what the SEC standard is for materiality as a defined term. And some of those considerations as to material events could be downtime, financial impact, rep harm, litigation risks, or IP losses. But that's going to be a challenge in terms of individual organizations' determinations of what is a material incident. And as I mentioned, vendor breaches, so those third-party organizations upon whom publicly traded entities rely all the time, if there's a breach or an incident at one of those organizations that affect and is a material impact to an entity, then they have to figure out the timing associated with that. And there's a 4-day rule here. There's a 4-day requirement subject to potentially national security issues, which might come into play. So that's a whole nother issue there. So challenges abound. And then there's this considerations around, right, what do I really need to do as an organization in terms of the talking about cybersecurity oversight and then explaining the cybersecurity risks. That's going to be potentially a moving target for organizations depending on size, shape, and industry.
Right. Yeah, that makes sense, especially because, attacks are always changing. So that's a great overview of some of the benefits as well as some of the risks that, insurers can be looking toward as this new rule gets underway. And then, Jim, what about you? What's your perspective on this in terms of some of the benefits as well as the challenges?
Well, I think that the purest benefit is that it will foster some consistency among disclosure standards and put insureds on a level playing field in how they do disclose their pre-event cyber posture, their post-event disclosures, and even the way they handle the event. So this will allow investors better transparency to evaluate the cyber risk, which is always useful. But, that does come with its challenges. As Bob touched on, these are complex events. And they have to describe the nature and scope of the incident, and they have to do it in a relatively brief period. These perpetrators are highly sophisticated and well-funded and very technical. And there's quite a bit for an insured to go through in a all-hands-on-deck moment when they have to deal with this administrative burden of managing the event itself, which has its compliance considerations. They have to deal with inside and outside counsel. They have to deal with their facilitators, their negotiators, their regulatory affairs, potentially law enforcement. So there's quite a bit to go through for an insured, and I can see this as being a burden, particularly for some of our smaller reporting companies that may be pre-revenue and have less of a robust risk management framework.
Yeah, that's a good point. It sounds like quite a lot to wade through and not a lot of time. So yeah, that is a big challenge. And, Bob, I know that you focus on cyber insurance specifically. So I was curious how cyber insurers will be affected by the new rule.
Well, I think the new rule, in theory, will help cyber insurers have a better understanding and insight into some of their book in the sense of how they are proactively managing the two parts of the rule in terms of the strong governance and just explaining the cybersecurity risks in play for a particular organization. The collection of data, either through external scans or question sets that are required at the time of submission, can only glean so much. Obviously, there's residual risk that we take on, and that's the whole purpose of the cyber insurance ball game. But ultimately, the goal here is to not have a claim. And ultimately, it's interesting that the rule has 3 parts to it: not only just the incident reporting requirement, but also just the governance and disclosure aspect to it, which should put us in a more informed spot when we are underwriting risks. And at the same time, you could argue that there might be less volatility as more organizations really do focus in on cyber risk management to avoid having to report an incident down the road. So ultimately, I think that is the goal, is to have more transparency when the bad things happen, but obviously to avoid those bad days, which could level out the playing field for cyber insurers.
Yeah, exactly. That makes sense. Transparency is always great, but it's even better to avoid, risks in the first place. So that's a good point. And, Jim, I know that you focus on the D&O space. So I was curious what the effects will be of this new rule on D&O insurers specifically.
Well, my concern is the new rules will spur event-related share volatility, and the management of such events can lead to securities litigation. So insurers will need to underwrite to the cyber posture of our clients and improve our own technical acumen to evaluate such posture. I foresee underwriters sounding a little bit more like cyber underwriters in their meetings, with the types of questions that we have to ask to get a better foundation and understanding of how our insureds are prepared, both pre-event and post-event. And Kevin LaCroix in his D&O diary, very accurately points out that the companies are going to be scrutinized for their pre-event posture, their post-event disclosures, as well as the actual handling of the event. And all of these critiques will come from the benefit of hindsight, which can result in material litigation expense for our insureds as well as the carriers.
Yeah, that's a great point. And I read Kevin LaCroix's article in preparation for this interview, so I'm glad you brought that up. It was a great article as well. So yeah, thank you both for that overview of how this might affect, cyber and D&O insurers. And, Bob, I know that you mentioned at the beginning of the conversation that, a lot of companies will need to be sort of rethinking their cyber posture and how they're approaching, cybersecurity risk management. So what are some of the best steps that companies can take to improve their cyber posture and also, ensure that they're in compliance with this new rule?
Yeah, well, there's a few items that come to mind. One would be just that strong governance, having that strong governance in place. So this just means enterprise risk management, having your appropriate committees and oversight by all reaches of the organization, not just putting it into the IT ranks, but having the appropriate budget and resources allocated to a chief information security officer and expertise in that department, but also ensuring that CISO is involved in all sort of IT development and decisions made across the network that are affecting all endpoints, such that there is proper risk management over the whole network that's then reported and governed in the proper way. So that strong governance piece is going to be required anyway. So we should be ensuring that is in place. Secondarily, that strong governance also includes a comprehensive incident response plan. So making sure that these new rules are factored into the incident response plan, how you delve into business continuity planning and disaster recovery planning, but also how you break the glass and who's involved when the bad day happens so that you can be prepared, and making sure that the response to report according to the SEC rule is part of that incident response plan. So an update potentially needs to be made there. I would also say managing that third-party vendor risk is critical. It's the weakest link piece, and the notion that you can have very good controls, but also outsource. We live in an outsourced world. So if you're relying on cloud providers, managed service providers, managed security service providers, software as a service providers, you're going to have to ensure that you've got the right contractual protections in place, the right remedies in place, but also just the overall vendor management that is so critical. So when they have a bad day, you don't have a bad day. And lastly, I would say employee training. It's a bit tried and true and tested that employees are many times that weakest link, and so ensuring that organizations have proper oversight and onboarding and consistent training of employees as to how they deal with phishing emails, how to contend with password management, and certainly clicking on the wrong thing is always a problem, and human error really is what's preyed upon by the threat actors. That's just got to be something that's going to be top of mind. So ultimately, all of that is more operational, but ultimately you also have to make sure that you're getting the right resources to deal with really best practices, but at a minimum best practices, which would be multi-factor authentication in the right spots, and ensuring that you are closing down open ports that the threat actors are preying on to get into the systems.
Yeah, that's all great advice. Third-party vendor risk management and employee training are two things that come up all the time in conversations about cybersecurity. So yeah, those are great points. And, Jim, you mentioned earlier some of the concern about litigation with these new rules, if the SEC brings enforcement actions against, companies or their, boards or directors. So I was curious what the steps are that managers and boards can take to sort of make sure that they're complying with the rule and, avoid any liability.
Sure. So my answer is probably going to sound very similar to Bob's, but it really comes down to prevention, preparation, and having a response plan. Our insured should be engaging experts and making sure they're partnering with their brokers, carriers, and external experts to make sure they have the products and services that improve their cyber posture and their event response. They should be doing third-party assessments, conducting tabletop drills, and involving areas of key risk management, as well as their disclosure committee. Because a company needs to be equipped to issue the AK and have the legal talent at the ready and under the circumstances of an event. And they should make sure that those wordings include the appropriate boilerplate allowances, because these are evolving situations and our insureds will be criticized for their level of understanding if that event goes poorly.
Yeah, that's great advice as well. It's so difficult to predict where the risks are going to go as they're constantly evolving, like you said. So that proactive, cybersecurity posture is so important. That's a great point as well. And, we talked a little bit at the beginning about some of the challenges with the rule. I know I've heard some concern that companies are worried about having to report because it might hurt their reputation or make them look vulnerable. So, Bob, I was curious what advice you would give companies worried about that, or, how you would respond to those concerns.
I think it's a logical concern, but ultimately organizations that they should be dealing with these issues already. This should not be anything relatively new to them, in the sense that they might just be needing to disclose to the SEC in their filings what they're doing with respect to their strategic risk management and their levels of board oversight of cyber risk as a major threat to their organization. I don't think that there's going to be a requirement really to demonstrate that, yeah, this is a vulnerability that we face, from a real granular level. It's just really about trying to demonstrate, as Jim earlier said, a consistent disclosure across the piece of cyber risk management and how different boards of directors, enterprise risk management committees, and C-suites are involved and engaged in this. I don't necessarily think that having to live into these disclosures and this oversight and transparency is going to result in bad press or reputational hits because, it looks like they are publicly saying that they have vulnerabilities that they haven't dealt with at this point in time. I don't think it's going to get to that granular level. But we'll see. We'll see what if there truly is consistency of approach and how the response happens come the effective date of the new rule.
Yeah, that makes a lot of sense. Thanks, Bob. And then Jim, on the D&O side, I've also, heard some concern that the reporting rules could, accelerate D&O insurers' efforts to exclude cyber incidents and privacy violations. Do you see that as a concern as well?
I don't. I mean, the cyber incident themselves typically are not a covered peril under a public D&O policy, but the event can lead to securities litigation, and those are clearly covered events. Public D&O is a very competitive and innovative marketplace. I don't see material restrictions to coverage coming down the pipe, and I anticipate carriers will collaborate with their brokers and clients to ensure that the products respond appropriately.
Awesome. Yeah, that makes sense. Thanks, Jim. Well, this has been a great overview of, some of the benefits as well as challenges of the new rule and, what insurers as well as, companies can be looking out for. I have one last question. It's for both of you, but I'll start with you, Jim. I was just curious overall, given everything we've talked about, what's the biggest takeaway for D&O insurers regarding this new rule? And, what do you hope for the future as it begins to take effect?
Well, I would suggest be prepared, engage your experts, examine how your suite of products ensure that there aren't any coverage gaps and consider any gaps that may be present. And hopefully this will improve the overall cyber posture and risk management practices of our clients.
Yeah, we can only hope, especially, in such a challenging threat landscape. That's, a great point. Thanks, Jim. And then, Bob, what's your perspective on this as well? What do you hope for the future?
Well, I just wonder if this is a sign of things to come, more active federal and state oversight, what's going to happen internationally as data privacy issues, come to the fore even more so, whether organizations are going to be really looked at to ensure that they're disclosing treatment of not only how their a data breach might be affecting them, but just essentially their overall use of data and how they share data and collect data. I mean, there's any number of ways of looking at that, but ultimately, is this really an active SEC as part of this administration? Is that a sign of things to come? Will there be more oversight that will be potentially helpful or challenging for organizations to meet their ongoing obligations? So it remains to be seen.
Yeah, definitely. It'll be interesting to see how all of this plays out. And, I've really enjoyed this conversation. So thank you both for taking the time to speak with me today.
Thank you for having us.
Yes, thank you.
That's all for this episode. Thanks to Greg, Bob, and Jim for taking the time to speak with me. And thanks to all of you for listening. Once again, my name is Elizabeth Blossfield, and I'm the host of the Insuring Cyber Podcast. a bi-monthly look into how the world of cyber and the business of insurance are connected. Be sure to check back for new episodes publishing every other Wednesday, wherever you get your podcasts. Talk to you next time.